All right, joining us this morning on a Monday morning is Atty Ruben Carranza, Senior Associate at the International Center for Transitional Justice. Atty Carranza, good morning to you, sir.
Good morning.
All right, I wanted to ask you, are you in the Philippines right now first before we start?
I'm in the New York area. That's where my organization is based.
So I should actually say good evening to you, sir. All right. So we're hearing a back and forth right now between the defense and the prosecution regarding the interim release of former President Duterte. Australia has denied they would ever considering hosting Duterte. Vice President Sara Duterte has said, we've never asked Australia. Is an interim release even possible in the first place with the crime he is accused of?
Of all the interim releases that have ever been granted by the ICC, two of them were after the persons who were interim released were already either acquitted, but the acquittal was on appeal, or the case was dismissed, but the dismissal was on appeal. There's a third case. It's a relatively minor case, although it involves a crime against humanity. The role of the person, a lawyer for the principal accused, was secondary. So it's the only exception in a way to the major crimes being crimes that should not involve interim release. So in all of these cases, really, what can be said is that interim release is an exception. As a matter of fact, under the ICC treaty, it's the defense that has to show that the conditions, the same conditions that were met for the issuance of a warrant of arrest, that those conditions don't exist anymore, or one of those conditions don't exist anymore. So risk of flight, the possibility of intimidating witnesses, the likelihood of appearing at trial, those were the conditions why Rodrigo Duterte was arrested in the first place, not just summoned, right? Because you had the possibility of just summoning him, he would volunteer to appear, but instead the ICC arrested him. So if those conditions still exist, then interim release will not be granted.
Now, do you believe the defense is making a strong argument at this point? Because they've also cited technically it's humanitarian grounds without mentioning, could they talk about his age, that he needs medical care? Is that something that he will not be able to receive at The Hague?
Humanitarian grounds, and specifically a person's health, isn't really a ground for interim release. There's something called a provisional release, which is different, and that's an even more temporary period. So, for instance, a former vice president of an African country was granted provisional release to attend the funeral of his father. Right? So you have those situations, but an allegation that a person is old isn't a ground for interim release. An allegation that the person is sick isn't a ground for interim release, precisely because you have healthcare facilities at the detention center of the ICC, and the ICC is in the Netherlands. The healthcare system can adequately address any kind of healthcare issues that a person detained at the ICC might claim to have.
And what is the procedure for this kind of request? Is this delaying the hearing itself?
Well, so the other important consideration here is that the previous interim releases were granted after a trial. So this one is being sought even before a trial has started. In fact, the pre-trial hasn't even happened. That's the one scheduled in September. So not only is this unusual, but this is also outside of the practice of the ICC. The second aspect to this is that I recall that one of the defense lawyers of Rodrigo Duterte, Nick Kaufman, claimed that the prosecutor's office had already agreed to interim release to a specific country. And you can see in the opposition of the prosecutor that what they did was to discuss conditions for release, for interim release, and not agree to an interim release. And those are two very different points. In the opposition of the prosecutor, it's very clear that they see Rodrigo Duterte as a flight risk, that he will not show up if the trial begins. Number two, that he will intimidate witnesses, given the power that he still has and that the family of Duterte still has in the Philippines. And so they cite the fact that he was elected mayor. They cite the fact that his daughter is vice president of the Philippines. They cite the fact that Rodrigo Duterte himself, just before his arrest, issued threats against ICC officials. So all these actions of Duterte and his family, in fact, undermine his own claim that he's entitled to interim release.
Okay, but attorney, reports have also come out. The defense has said the prosecution has agreed it's just a location. But is it true, a location? But is it true that the prosecution in the discussions is considering an interim release if it's their country of choice? Is that accurate? Because that's come out in the reports.
That's not accurate. Like I said, what the prosecution has said is that they agreed to discuss conditions for interim release, and those conditions have varied. The two previous high officials who were granted interim release were released to Belgium, and one was released to the Netherlands later on. Separate agreements have to be made between the ICC and the specific country for which release is possible. So what the prosecutor has agreed to do is to discuss whether these countries will agree to the conditions set by the prosecutor, not that the prosecutor has agreed that a country that agrees to the release will automatically mean that Duterte will be released to that country.
Okay. Would you say then the two previous interim releases, they were in Belgium? Or one was in Belgium, the
other was in the Netherlands.
Okay, now coming from this, the history of the ICC, do you believe it could be any of those two countries that the defense is actually hoping on? Because they did say that one of the concerns of the prosecution was the country that the defense had mentioned is not cooperative to the ICC. Is that correct?
They also mentioned that one of those countries that were named perhaps is very distant.
It's not either.
No, the point here is that any country that's proposed to be the country to which a person in detention at ICC is released has to agree to very specific conditions. Some of the conditions can be very, very specific. For instance, naming a police station to which the accused person will report regularly. A condition in which the person will notify the government of that country about his whereabouts every day, wherever he goes. So there are very strict conditions. Now, the application as well as the opposition are redacted documents, meaning the names of the countries have been removed, and so only the court and the lawyers involved have access to those countries. But given the record of the ICC, given that Belgium, the Netherlands previously accepted interim release persons, it's possible that these are the countries being requested. But I think Filipinos should not be distracted by which country is willing to accept Rodrigo Duterte. I think Filipinos should focus on the fact that Rodrigo Duterte has not shown that the conditions for his arrest have changed, that he has not intimidated witnesses, that he is not a flight risk, meaning someone who will not go back to The Hague for a trial. And there is nothing in the application that says anything of that sort.
Do you believe this also to be a political play? Because without the request for an interim release, what's interesting is you said usually interim releases are discussed after the trial has started, not even before the trial. Now, do you believe this is a tactic of the defense to keep him in the news? Relevance.
So one of the examples of interim release requested, denied, and then later granted is the former president of the Ivory Coast, who was arrested there, taken to the ICC. He kept asking for interim release during his trial. This kept getting denied. He appealed the denial of the interim release. It was also rejected. One of the reasons why they kept rejecting his request was because, according to the ICC, he had a very strong network of supporters back in his home country. They specified the names of the political party.
Yeah.
They even mentioned that his wife, the first lady, former first lady, was in one of the leaders of this network. So they kept rejecting his request. Now, his case was later dismissed. He applied for interim release. That was when he was released. So you can see the pattern here that when there is no longer a reason, or at least the likelihood of a person being convicted and sentenced no longer is high, he can be released. Now, take note that in this example I gave, the person, Laurent Gbagbo, former president of the Ivory Coast, was already in detention for 4 years before his interim release was granted.
Because when his interim release was granted, is it right? His case
because the case was already dismissed.
Exactly.
The only reason he was still detained was it was on appeal.
Okay, so interesting. And you talked about the influence of the wife, the political networks. So you see a similarity with former President Rodrigo Duterte, the daughter being a vice president, the son now possibly taking over as mayor of Davao. What happens now? I want to ask you that. Former President Rodrigo Duterte won by a landslide as mayor of Davao. Is it possible for him, under any circumstance, to take his oath while he is detained?
He can make a request. He hasn't made a request to take his oath. We don't know whether he wants to take his oath in the first place. I think that this may not reinforce the intention of Rodrigo Duterte to get interim release, because if he's mayor and he takes his oath, right, then he will have the powers of a mayor, and that will only add to the reasons why he should not be granted interim release. He would be a sitting public official in the biggest, technically one of the biggest cities in the Philippines, with all the power that brings. Now, I think there's a pattern here in which Nick Kaufman, the lawyer of Rodrigo Duterte, has tried to undermine not just jurisdiction, which he has every right to question, but to essentially raise political challenges. The court kidnapped Rodrigo Duterte. The arrest was illegitimate, while at the same time asking the same court to grant interim release. So namamangka sa dalawang ilog, and I think that's the problem here.
Okay. The Philippine Department of Justice Secretary Jesus Crispin Remulla, in a press conference, has said, driven by the significant challenge of destroyed or absent evidence, the government is choosing, or has chosen, not to pursue the war on drugs, a case in the Philippines. But you have the Justice Secretary himself saying that most of the evidence here has been destroyed. Crime scenes have already been manipulated, right? They have not been preserved. So he says it's difficult to prove the case in the Philippines and build up the case, hence entrusting it to the ICC. Do you see this as a weakness? The fact that the Justice Department himself agrees that evidence is absent in the Philippines?
No, well, actually, I don't think that he understands the distinctions between an ICC trial and cases being filed in the Philippines. That's why there's complementarity, a basic principle at the ICC. That's also why the ICC prosecutes high-level officials, because the idea is that lower-level officials involved in the same crimes can be prosecuted back in the country where they are. And there is no reason why the Department of Justice in the Philippines, which under Duterte and then earlier under Marcos, actually reviewed all the EJK, all the extrajudicial killing cases connected to the drug war they even submitted these case files to
Yes.
the ICC.
Oo. So meron. May ebidensya.
Meron, they submitted. In fact, the reason why the ICC proceeded with the case was that the case files were haphazardly done, but they exist. They were done in such a way that the Philippine National Police and the National Bureau of Investigation narrowed the number of cases to about 50 when there were tens of thousands. And so the ICC said that this is haphazard filing, and so we will proceed with our own investigation. But this also tells you that the Philippines actually has the evidence, actually has the records, actually was able to submit them to the ICC and can do what the ICC did, but for lower level officials. So even for officials of the Duterte government who were involved in the drug war, a former PNP chief, for example, or perhaps even a former DOJ secretary. And so there is no obstacle really for the Philippine government not to conduct its own prosecution. In fact, there is a law in the Philippines. It's a crimes against humanity law that can be used locally before domestic courts. It's not just murder, but also the same charges that have been filed against Rodrigo Duterte can be filed in a domestic court in the Philippines against people below Duterte for drug war crimes.
So with just what you've revealed right now, what you've shared, do you think that the government actually is playing Pontius Pilate? It's washing its hands of the Duterte drug war case because of the Duterte's popularity?
It could be about popularity, but I think I think it's really about power. That Ferdinand Marcos Jr. Surrendered Rodrigo Duterte to the ICC so that Rodrigo Duterte and his family would not have the strength to challenge the Marcos family for power. This is not about accountability. This is not about justice for victims of the drug war. This is about the Marcoses removing a threat to their power and the Duterte family trying to come back to power. And that's the unfortunate side of this, Karen. You throw a case to the ICC not because you're interested in finding justice for tens of thousands of people, mostly poor people killed in the Philippines, but because you want the power for yourself.
Because what's interesting is you just heard the statement of the spokesperson of Malacanang saying, we are not directly helping the ICC, we are indirectly helping the ICC. And that would be, I guess, protection for the witnesses to be used in the ICC, right? The Department of Justice protecting the witnesses. But we are not directly helping, we are indirectly helping. I mean, frankly, it seems like, it's cowardice. What do you make of that?
Well, first of all, the Philippine government actually has obligations to cooperate with the ICC, regardless of the withdrawal of the Philippines from the ICC. This obligation arises from the fact that even as a non-state party, there are residual obligations because of the fact that the cases were filed prior to the withdrawals taking effect, or at least the preliminary examination, right? So there is that legal argument. But outside of that legal argument, there is a witness protection law in the Philippines. So that law obliges the Philippines to protect witnesses. When I was in the Philippine government, we used some of that witness protection law in PCGG cases. So the second thing here is that the ICC has its own witness protection agreements with certain countries, right? So only with countries that are members of the ICC. So in that perhaps is the situation where the Philippines can claim we have no agreement with the ICC for witness protection, but the ICC itself can reach out to other states to protect witnesses, including those witnesses who are no longer in the Philippines. So what we're really talking about here are witnesses that are still in the Philippines, not witnesses that are no longer in the country.
Attorney, could the Philippine government, could the Marcos administration handled this better? How did other countries whose leaders were sent to the ICC, how did they handle the political backlash, let's say, of a popular leader being arrested or being sent to the ICC?
So, again, in the two cases I mentioned, high-level officials, right? Laurent Gbagbo was former president. The government of the Ivory Coast actually prosecuted his wife, the First Lady. They did not surrender her to the ICC because they said they could prosecute her at home. They prosecuted other lower level officials of Laurent Gbagbo's government involved in crimes against humanity. So, a government that is truly interested.
But what reason? That's very interesting. Kasi tama kayo. Pwede namang sa lokal na pamahalaan, kasuhan nyo. 'Di ba? Yung ibang mga akusado. Pero what reason did the existing government of the Ivory Coast give why they could not prosecute the leader? Kasi ang binigay, sir, ang binigay ni President Marcos Jr., it was, we have to cooperate with the Interpol. So nangyari, hindi kumagat Hindi kumagat yung taong bayan doon.
So the specific situation in the Ivory Coast was that there was a war going on in which the government could not simply move against the former president given the number of supporters that were backing him. And so the ICC was involved because there was already a pending case against him as well. But, overall, I think that a government that is interested in justice, in accountability, including in the Philippines for the drug war, cannot just say prosecute this one person as if that single person was the only one who killed 30,000 people. That's impossible. We know that. So there are many more persons that ought to be prosecuted, and letting the ICC go ahead and prosecute Rodrigo Duterte denies justice to Filipinos because there are more people who ought to be investigated, who ought to be prosecuted for that drug war.
That's the strongest point you've made today. If the Philippine government is listening right now, do you advise the Philippine government to actually start prosecuting others involved or suspected of being involved? The names that have been mentioned, you have Senator Ronald Bato de la Rosa, former PNP Chief Albayalde, and a few others. Do you recommend that the Philippine government take action on them?
Well, they held congressional hearings in which they compiled massive amounts of evidence against these people, and even admissions by these persons of who directed them to do what during the drug war. So there's really no reason. You can't say I'll have to start all over again. You can't say the evidence has been trashed or erased, because the evidence was just there, sent to the ICC, and now a new round of evidence has come up in these congressional hearings. So there's really no excuse not to go after other people, not just Rodrigo Duterte, for crimes committed during the drug war.
Okay, now wearing your hat as a former Presidential Commission on Good Government, or PCGG commissioner this time, what do you make of how the impeachment case of Vice President Sara Duterte is shaping up right now? Two questions on this. Yan muna tayo. What do you make of that?
I'm just dealing with the whiplash of shifting to this. Well, first, this reminds me that there was a previous impeachment attempt against a president filed by several opposition leaders in the Philippines, equivalent of Congress. The impeachment complaint that they filed was dismissed outright by the majority controlled by the government. And this was in 1985, when the president was Ferdinand Marcos Sr., and his KBL simply dismissed an impeachment complaint filed by the opposition at that time. So, in other words, this motion to dismiss discussion that's happening, as I have read, follows a Marcos pattern, and that's the irony of it, because the same persons who are questioning Marcos Jr. In the impeachment case and his role in it are using the Marcos tactic of simply dismissing outright an impeachment complaint. I think impeachments are always inherently political. The process is legal. There's a clause in the Constitution, and I know that Filipinos have been debating what forthwith means, and I think that debate has been settled. But you must remember that the same sentence that includes forthwith talks about a trial must be held forthwith. So the trial part is just as important as the forthwith part. It doesn't say
And
proceedings must be held.
Ang tanong ko, is dismissing the case considered a trial must be held forthwith? Because Senate President Cheese Escudero said, our power as an impeachment court is limitless. We can do what we want. We have the sole authority to try and make a judgment. And some interpret this as you can acquit, you can convict, you can dismiss.
He's trying to bank on the nature of the Senate as an impeachment court, and therefore the power of a court to promulgate its own rules. But it's not correct. He's wrong in saying that her power is limitless. The Constitution gave them that power, and it's the Constitution that explicitly mentions the word trial and explicitly gives them the power to try and make judgment. It doesn't say to hear a motion to dismiss and then decide, right? So the word try is very specific. It has a technical meaning for lawyers. It has a technical meaning under the Constitution. A try means to go to a trial. And that's what the Senate, the power to promulgate rules during the trial is wide. But there is no power to not conduct a trial.
Okay. The last question is, there have been talks that the vice president might throw her hat into the presidency in 2028. If so, she would be leading as of today. She would be the winner as of today if elections were held today. Sources tell me that if she does run and win, she would bring back the PCGG. Now,
okay.
What are your thoughts on that? Allegations of corruption with this government, with the 2025 budget, once again, properties, wealth, there is no formal investigation. But that's the one thing sources say. If she wins, she will bring back the PCGG and once again, prosecute the Marcoses, get back ill-gotten wealth. What are your thoughts?
I don't know why she has to wait until 2028. The PCGG is still there. As a matter of fact, not only that, the case, many cases have already been decided. What she ought to do is make sure, using her office as vice president, when you go on social media, for example, most of the Duterte supporters' attacks against the Marcoses involve Marcos as a drug user, Marcos as this, Marcos or that. They never seem to want to attack him for corruption, for ill-gotten wealth. And I don't understand why they won't do that. So they can do that. Not only can she demand that cases that have been decided against the Marcoses, including the criminal conviction of Imelda Marcos, right? That her bail should be rescinded, for example, in the same way that her father, Sara Duterte's father, cannot be granted interim release. Why should Imelda Marcos, who's been convicted, Rodrigo Duterte has not even been convicted, he can't be released, but Imelda Marcos convicted, so maybe she should demand that. But not only that, there's a tax liability of the Marcoses that they haven't paid. I don't understand why the Duterte family doesn't seem to be interested in accountability for corruption. The same allegations of corruption that have been made against her in the impeachment trial.
All right. Well, on that note, I want to thank you. If they ask you once again to join the PCGG, is that a yes or a no?
I'll have to consider whether that's a serious proposal she's making. It looks to me that it's not.
All right. On that note, Atty Ruben Carranza of the ICTJ, thank you this morning. Interesting discussion, sir. Thank you.
Salamat din.
Never miss a story. Unlock exclusive access to uninterrupted streaming and premium news content. Subscribe to ANC 24/7 on YouTube and join ANC Prestige today.